conference
No,
will now be
no worries.
recorded.
And you were starting off at 8 different
Right,
programs
right,
or
right,
okay.
right. The so let me see if I can get this back up the way I wanted to share it. Um, so, anyways, there are 8 providers. There are going to be a number of different areas, and so I would encourage you to stay tuned because there will be a number of other training opportunities that will be offered to the Kern Regional Center IDD community over the next year. The grant cycle went from October 1st to September 30th of 2026. So keep an eye out. Like I said, Helen Sanderson is a sort of an international organization that's done a lot of work in this area, especially person-centered planning. She's going to be doing some work in our area. Tom Pomerantz is going to be coming out again. The who else? Path Point, who's another adult day provider, will be providing some training. The Valley Achievement is going to be providing some training. And then there are 2 others that are new to the area, or new to me anyway, and they will be also be providing some different materials. So in addition to that, we will continue to, Bakersfield ARC will continue to put out that monthly newsletter, which if you're not receiving it, contact Irene, the same person that you contact, or Valerie, and let them know, and we can get you put on the mailing list. This month's that just went out a week and a half ago was on futures planning and how do you work with individuals about planning for their long-term future. If you look at the new IPP format, and Valerie just put her website, or I mean her email address on the screen. So if you want to get a hold of her and make sure you get on the newsletter, we would appreciate that. Anyways, long-term planning for folks is something that we don't oftentimes do. That most of the time when we sit down and do an IPP, and now it's person-centered, it's to the immediate services and supports that the person is receiving. So what are they receiving is in regards to a purchase of service, and what purchase of services are they receiving? Also, what services are they receiving generically through maybe their Medi-Cal, Medicare, other resources that they're utilizing in the community. And then we may put in a goal that is like 3 or 5 years, but that tends to be a not that specific, and it really doesn't look at practical planning. So this month's newsletter really talks about how we can go about doing some practical planning in a number of areas. So if you have, let's say, people that you're serving in, let's say, your day program, and they're living with elderly parents. And the elderly parents are now getting to the point where they may need to start receiving some assistance, and their ability to continue to provide the home assistance for that individual may be becoming somewhat challenged. Something to plan for. So if we don't find ourselves, which when I worked at the regional center, it did happen from time to time where, let's say, the one of the 2 parents or a single parent who was providing the care was no longer able to provide the care, deceased, or situation changed, and overnight we had to figure out placement for that individual. It was a very disruptive process. So thinking about long-term planning for people, also financial planning. If there's any trust that's going to be set aside for that individual, those sort of things. How do we go about doing that and making sure that that's done in a way that will benefit the person and will not in any way harm their ability to get public benefits? So those are all things that we really need to do more planning on. Something I had thought about when I still was at the regional center and was starting to move in that direction. And I don't know that much has been done in that area. The national ARC has a futures planning guide that you can use free of charge if you just go to their website, thearc.org, thearc.org, and then type in futures planning. It will come up, and then you can just tap on it, and you go into it, fill in all the stuff, and it will really help you to help the individuals you work with on making a much more in-depth future plan than what ends up being in the IPP. And that's this month's newsletter. I got off on a little bit of a tangent there, but I think it's important that we really talk about that. Okay. One of the things that Positive Purposes, which is one of the other grant providers, has available now is if you are a provider who's finding yourself having to crosswalk, move to where you were as your vendor code to a new vendor code and needing to revise or rewrite your program design, Positive Purposes is available to provide you with technical assistance that they will review your program design and then give you suggestions and areas that you could do that you might be able to enhance your program design, and also to make sure that it's consistent with home and community-based waivers. And an example being that I've looked at a few where people have talked about their entrance criteria, and one of the things that they didn't necessarily think about was that as a vendor provider, you can take individuals under self-determination. If someone goes on a self-determination plan and then wants to negotiate with you to provide services outside of the typical vendored rate, that can be done now. And people did not put that in there. So they were sort of not taking on potentially another source of revenue, of receiving clients, of being able to provide specialized services for individuals. So that was something that just an example of something we've added to some plans that as we've provided technical assistance for folks. Okay, so today we're going to talk about rights. And first of all, the first thing I want to talk about, and at the very beginning I said some of this stuff is going to be like current, like happening today almost. The understanding IDD, we all seem to think that we know what IDD is. It's intellectual disabilities, cerebral palsy, autism, epilepsy, and then conditions similar to IDD or requiring similar treatment. But that's not exactly the case always. There are medical and clinical definitions for IDD, and then there are political definitions. And the reason I bring this up is currently there is a case that is just about ready to go to the U.S. Supreme Court. And it's Ham versus Smith. And it's out of Alabama. And what it is that over the last 30 years, the Supreme Court has decided that to execute an individual who has an intellectual developmental disability is cruel and unusual punishment under the Eighth Amendment of the Constitution. Well, in the case of the case that I've mentioned here, the individual was tested a number of times and got scores on an IQ test in the 70s. And Alabama is saying, well, intellectual disability is a score of 69 or below. That's where that puts you in the mild range. If you're in the 70s, you're in the borderline range, and that we don't consider that to be an intellectual disability. Now, clinicians look at intellectual disability, and they also look at adaptive functioning, your ability to take care of yourself, bathing, grooming, dressing, toileting, community skills, your ability to handle money, your ability to interact with others, to communicate receptively and expressively. They look at a number of things. So they're looking at adaptive ability, your ability to your functionality, as well as your intellectual score that you get on a paper and pencil test that is given to you. Historically, the Supreme Court has taken the position that it is both the cognitive functioning as well as the adaptive functioning. But in this case, like I say, Alabama is saying, no, it's just the cognitive functioning. So if somebody scores over 69, they don't qualify for this to be able to fall under an intellectual or developmental disability. Now, the case itself is about someone who was found guilty of a crime, and the issue is whether they could be executed for that under the state law. So it's very narrow, and there aren't that many individuals with IDD that come before the court under those circumstances. But what it could do is if all of a sudden the courts are now saying, well, no, you just look at the intellectual, the IQ score in terms of making that decision. There are people who, score above that 69 mark, but who could clearly benefit and are basically providing a level of functioning or showing a level of functioning which is very similar to that of someone who has an intellectual disability. So will the court look at the Alabama position, which is we just look at the IQ alone, or will it look at what the clinical model currently is, which is both intellectual and also adaptive? So stay tuned. That is on their docket. That's one of the cases that the court's going to review this year as they go through their decisions. Historically, the court has looked at precedent, what cases that have come before, and sort of stick with that. The current court is doing things a bit differently, and so we'll have to wait to see how they do that. But it could potentially, in the long run, affect how states define intellectual disability in terms of eligibility, in terms of services, etc. So. Okay, the importance of rights. Rights ensure dignity, access to opportunity, and protection from discrimination for individuals with IDD. Now, that's really important because that's not the history that we work with. If for any of you who have been around for any period of time, you'll know that this is more of a current situation where we're providing people with full array of rights. There was at one time individuals who went into the state developmental center here in California were almost routinely sterilized, and that was done because we were trying to prevent persons who were considered to be mentally defective from having children. And so this was done without their consent. The courts had said that was okay to do, and other things over the years, decision making for people. The whole area of conservatorship is really changing in terms of how we do individuals' rights. There, now in California, we have limited conservatorship, and more we're trying to go towards supportive decision making, which is where we help somebody able to make their decision. And there are some courts here in California that are very reluctant to give consent under a conservatorship for psychosocial sexual rights, because they really believe that that's a personal right that everyone should have to be able to make friends, to have personal relationships, to have intimacy, and that shouldn't be something that a third party should be making decisions about. Legal and social protections. We want to make sure that our folks have the same legal rights as anyone else and the same protections. A number of years ago, I was working with a group of folks who were using a social recreation center, that was community based, and the person that was in charge of that center came to the group and said, "Well, this isn't really set up for you guys. This is we're more for the community. You guys have your own service system, for through regional center. So please, refrain from using our services." Can't do that. People have the same rights as anyone else to those services. So if they meet the same criteria, they live in that community, that's a community service, they have a right to utilize that service. There are a lot of remaining challenges that are out there. Stigma, interesting enough, many in our field have fought for many years to remove what we now refer to as the R word. So when we refer to people as having an intellectual disability. In the past, we used it, as having the R word. It's coming back. We're starting to see people using that term again, and not necessarily getting called out for it. So we need to make sure that we address stigma when we see it. So we see people using terminology that's outdated and sort of derogatory towards the people that we serve. We need to speak up and say, no, that's not a term we use. That's old way of looking at things. That today we want to respect people, and that term has connotations that aren't very positive. So let's move on. There's a lack of awareness. I at one point was working towards the development of a specialized home for individuals who had medical challenges. And there was it was in a community that was fairly tight knit, and the community came together and tried to oppose the opening of that home. And one of the things that they were saying was that they felt like their safety and could they allow their children to continue to play outside, and was this going to all somehow change the neighborhood so that it would, and not for the better. And as it turned out, the individuals who lived there, because of their medical fragility, were probably at more risk from the neighbors' children, possibly doing something than they proposed to the neighbors. And so it was a matter of just educating the folks and providing awareness as to know why these people needed this type of facility, how that really benefited them, how it benefited the community, how it was more cost effective, all the positive things that would come out of having this home as your neighbor. At times we find that there's insufficient supports which hinder full inclusion. Now, one of the biggest problems is funding. And the funding that the system receives is such that it's very difficult in many cases to develop and to maintain the resources that are necessary. Now, if you're a provider of services and you're being funded at 1 to 6, 1 to 4, etc., and you're being told, wait a minute, you need to go out into the community, you need to provide individuals with individualized support to try to get them integrated into the community and do all these things. Well, if you've got 6 people, how do you integrate and you're the one staff person in the community? So when you're if you're going out to go shopping at the Valley Plaza, for example, and there are 6 of you with one staff person, it stands out. I mean, I don't know how many times I've been to the mall or to the marketplace or someplace else here in town, and I see a group of folks and somebody's with them, and I immediately know that they're individuals who have a disability, and they're out on from their adult day program. They're out from their residential facility. They're utilizing the community, but it's not going to bring about full inclusion when you've got those sort of ratios. But those ratios are based off of funding. That there are people in the Department of Finance who look at basically it almost works in reverse, so that the governor comes up with and the finance department come up with a number of how much support they want to give our system in a given year, and then we back into how much we can provide for those folks based off of that. Now, technically, in California here, we have an entitlement, which means that if it's written into someone's program plan, and it's not available through any generic service, then it needs to be purchased through the regional center. But that then makes a couple of assumptions. One is that it's available, that there is a provider who can provide that particular service, and that there's also a vacancy or a ability for that provider to take on more clients, because some individuals have said, no, we're not taking any new folks because of the costs associated with providing the services, or we're retrenching what we're doing. There have been a number of programs statewide and throughout the country that have closed in the last few years because of the cost of doing business and the reimbursement rates that they receive. So that continues to be a challenge to the system that we provide. Okay. Okay. Human rights frameworks. There are a number of frameworks that are out there, and I'm just going to talk about 3. The United Nations, which is a worldwide organization, has a convention on rights and promotes the protection of human rights for persons with disabilities worldwide. So if you were to go to the United Nations website, you can look up and you can see what their positions are specific to the rights of individuals with disabilities. And in most, if not all cases, they parallel or are the same as they are for any other individual. And the whole idea of separate is not part of that equation. In the United States, we have the Americans with Disabilities Act, which is the whole idea of reasonable accommodations and to try to make the community, workplaces, schools, etc., transportation accessible to persons with disabilities. And then finally, one of the other ones that I want to talk about just very briefly is what's called the Olmstead decision. It was another Supreme Court decision, and it was dated from 1999, and it came out of Georgia, that there were 2 women who lived in an institutional setting and wanted to live in the community. And the state said no, that they thought it was more cost effective to have them living in the institution, which I don't fully understand, because I know here in California that it became much too expensive to continue to operate the institution. So a combination of that, the humanity and the benefits and everything else that was involved with providing community services were paramount, but also it was more cost effective to provide the services in the community. So that's, not something I fully understood how it was more expensive to live in the community unless the state of Georgia was providing minimal services to people in the institution. But anyways, the Olmsted ruling affirmed the right to live in the least restrictive community setting for individuals with disability, establishing that unjustified segregation of people with disability in institutions is a form of discrimination under the Americans with Disabilities Act. So we have a Supreme Court case saying people should be living in the community. And the Olmsted decision really was a shot in the arm for the home and community-based waiver. So here you had the Medicaid system here in California, Medi-Cal, that had this program that was part of the voluntary services that states could do specific to community-based services for people who would otherwise live in the institution. And now that the Supreme Court was saying people shouldn't live in the institution, if a community alternative, if it's less restrictive to have them in the community, is out there, and that really was a major impetus for the further development and growth of the home and community-based waiver. Okay. So what are some of the core rights? So if you're looking at big picture, access, a right to education, access to inclusion and supported learning environments is essential for individuals with IDD. And at the federal level, there is the Individuals with Individual Disabilities Education Act. It's called IDEA, IDEA. And that's been on the books for many years, and it guarantees a free and appropriate education for anyone ages 3 to 22. In addition to that, under the Early Start program, which falls under that as well, 0 to 3. It has a separate set of rules, but that also is a right to an education, a right to employment. And if you look at the very first rule in the home and community-based final rules, it talks about someone having a right to an employment setting if they so choose. And that should be part of every IPP that we do, is that be discussed. Even if the individual says, no, I continue to want to be in day services, or I don't want to go to a program, I want to do something else with my time, it needs to be available as an option and a viable option. And again, as we mentioned earlier about problems with things that can impede full inclusion, funding can be a challenge too sometimes for providing the opportunity for folks. They're getting people into services that provide pre-vocational services, that have job coaching, that have internships, that have supported employment, that have community integrated employment opportunities, can sometimes be limited in terms of availability. A right to health care. If you look at a lot of the statistics that are out there that have been done over the years, where they look at health outcomes for people with disability, they tend not to be as good as they are for the general public. And there are a number of reasons for that. And I can't go into all of that today, but suffice it to say that Medi-Cal is a public benefit. It doesn't necessarily pay the same rates as insurance. So sometimes the resources that are available, again, because of the funding issue, are not as available as they are for people who can maybe private pay or can use insurance. Secondly of all, are the individuals we serve aren't always as articulate and can't always express what is going on with their health care and aren't always encouraged to be active participants in managing their health care. And so that also is a factor. So we want to try to make sure that persons with intellectual and developmental disabilities get the same health care. I told this story before, but when I was a child, there was a family that lived down the street from us who had a son who had Down syndrome. And we were told as kids, pity that family because that child won't live past their early teens. And that was the thinking back in the 1950s. And it would, because of heart problems, lung problems, other issues, the longevity of persons with Down syndrome was tended to be very short. It could be into their teens in many cases. Now, what we're finding is that some of the individuals we serve are in their 50s and getting into their 60s and are developing dementia. And they think that there may be a correlational thing related to the 21st chromosome, which is what causes Down syndrome and dementia, something we would have never, ever seen or thought about or had a concept of back when I was a child, because people didn't live to that age. Right to community living and self-determination. Regional Center is really pushing the whole concept of self-determination now as an alternative to traditional case management. That's where someone gets a budget and then can manage their own services, and they can manage those services through either traditional service providers, contracting with them themselves, or going outside of the regional center system. Self-determination is part of the home and community-based waiver services. It comes with federal dollars, and there are some restrictions in terms of how you go about doing that, what you can and cannot use the money for, how you have to do reporting. You have to have a fiscal intermediary. You have to have somebody assisting you with putting the plan together. There are some challenges with it, and some families find it, or some individuals as well, find it too difficult to initially do. But if you can get past that, there have been a lot of very successful things that have gone on, and people have been able to do an alternative to traditional case management and purchase of service. And then a right to community living. And again, that the Olmstead decision and also California's legislation and legislators have said we want people in the community. And currently there are close to around 500,000 people in the California Developmental Services System. There are about, I believe, 250, maybe 300 that are living in institutional settings, primarily individuals who are in a forensic situation where they're living at Porterville Developmental Center has a unit for folks that are a danger to self or others or not competent to stand trial. There are a limited number of people with very severe medical issues that are in some state institutions, some people who are nursing facilities, but for the most part, of those close to 500,000 people in California, almost all of them are in community-based settings. And then California is unique among the 50 states in that we have an entitlement to services. And what that means is that you can walk into a regional center and say, I believe that I have a developmental disability. Regional center will then do a preliminary assessment. If they find that there's enough to potentially do a full assessment, they'll do a full assessment. And if that assessment finds that you do have a developmental disability, a plan is written, and based off of what's in the plan, you will receive those services. Now, in other states, there is, in many cases, a waiting list for services. So even if you have a qualifying condition, the state only has so many spaces for people to receive services. And they have a specific allotment of money that's out there to provide those services. So if you are fortunate enough to be in the system, you get these services. Not all the services, but these particular services. If you're not, if you're new to the state, you're just coming in, you were just found eligible, you may wait sometimes for many years until either the state increases the number of people they serve, people leave the state, people die, and vacancies open up. And the next person on the list moves into a slot. I don't know what it is currently, but in the past, I remember hearing that in the state of New York, if you wanted to have your adult son or daughter in residential care, you should sign them up when they were a small child, because it was going to probably take about 18 plus years for that vacancy to become available for that. And I don't know if that's still the case. May very well not be, but it's just an example of how waiting lists can really affect services and make it so that what's needed and what is available are not in sync with each other. In California, there was a case that came out of the 1980s where the California legislature was, there wasn't, there was a recession and services had to be cut. And so they did what was called the Basic Habilitation Plan as part of the IPP. And that plan said that, okay, a residential living situation, a day program or work, and then healthcare would be top priorities. And then a line was written across the IPP. Those three were addressed first. And anything below the line, California would provide if funding was available. And the ARC, actually the one in San Diego ARC, and then it was joined by the California ARC, sued the Department of Developmental Services, and it went all the way to the state Supreme Court, and the California Supreme Court said, no, the legislature, if you read the preamble of the Lanterman Act, Section 4500 of the Lanterman Act, it specifically says that these are an entitlement. This is a responsibility that the state of California has taken on for its people to provide this level of service. And so that is what we currently have. Now, that language can or be changed at some point in the future if California finds itself in such dire financial situation that it says we can no longer provide that entitlement. And then the legislature can go in and say, this was our intent, but now our intent is over here. But as we stand right now, we are the only entitlement in the country, and it would be politically very challenging to look at changing that, because the people who are in the California system have made it very clear that we want to maintain that entitlement to services. We find that this is really a unique situation that we have, and something that really benefits the people that we serve. Okay, some of the barriers to people that we serve, stigma, people assuming things about folks who are disabled, and especially intellectually disabled, or cerebral palsy, seizures, other things. At one point I was doing some training with law enforcement, and sometimes they come across someone with a disability, and it can be they have to use their professional skills to figure out what's going on. So if someone is let's say has cerebral palsy and is sort of unstable and is kind of slurring their speech, is that someone who is intoxicated? drugs or alcohol, or is that a disability? And that's something that the officer might have to make a decision about. Someone with autism that doesn't respond appropriately to the officer, maybe takes off. Those sort of issues can be of a challenge. So, working with the first responders to make sure they have a better understanding of working with our population, because they want to do what's best for our folks. But sometimes in a situation they may not know. And so providing them with that knowledge is important to make sure that our folks are properly served. And we want to where we see discrimination. So if we go someplace, oh no, that's not allowed here, or we don't, your group, could you please take them somewhere else? No, that's not permissible. We want to call that out and do what we can to make sure that doesn't occur. And as I mentioned earlier, lack of accessible resources. Sometimes you find that a particular setting, someone can't take advantage of it because they can't get their wheelchair in, or they need American Sign Language skills, interpreter, and that's not available. And so how do we go ahead and make sure that we have reasonable accommodations to really meet the needs of the persons that we serve? And then institutional effects. There are still institutions out there. Although California has closed all of its state developmental centers, state hospitals, except for Porterville, Illinois. As I mentioned earlier, Porterville is specific to persons who are there because they're involved with the court system. Many other states still do have state developmental centers, state hospitals. And there is, as we see Medicaid, the federal level, the $800 billion that will be taken out of the system over the next 10 years under the recent budget changes for our current administration, how much of that will move us back towards institutional settings as we don't have the funds available to provide community-based settings? And that's an unknown. There are some advocates who are saying that that's going to occur. There's also a very strong community-based movement that feels like we can continue, and we're just going to have to sort of figure out ways of doing things differently, more creative, more cost-effective, et cetera. And I don't have the answer to that. Limited legal representation. If you're aware of, there is Disability Rights California, DRC, and then they also have the Office of Clients' Rights Advocacy. They have much greater demand than they have the capacity to provide the service. So in many cases, they will give information and referral and try to assist the best they can, but to get actively involved in a case, they have to sort of be very selective in terms of taking on, major roles because of the resources, and making sure that they can spread the resources across the full continuum of services that are needed. And it, like everyone else, it's a challenge. They want to do the best, and they do a very excellent job with the resources that are available to them. Okay, just this last week, so this is like current. In the past few days, a reduction in force ordered has cut staff at the Department of Education. This is at the federal level, because of the current budget shutdown, government shutdown. The administration has decided to eliminate positions in certain departments. And the Department of Education was one of the areas that they've eliminated positions, with impacts on the Office of Special Education and Rehab Services, as well as the Office of Civil Rights. And then 400 plus people receive termination notices, will see their jobs eliminated within the next 30 to 60 days. This raises challenges as to how California's vocational rehabilitation agency, so if any of you are working with the rehabilitation agency and California schools, will be able to continue to provide services to people with disabilities without funding and support that comes from OSERS, the Office of Special Education and Rehab Services, and Rehab Services Administration. So we're seeing cuts at the federal level. And so just like I mentioned earlier about the Disability Rights California having their the needs greater than their resources, the ability to file a civil rights complaint against the school district, which historically in many cases went to the federal Department of Education, who would then provide civil rights assistance to that family, to that individual, is being very greatly reduced with another 400 staff positions eliminating at the federal level. And that's not only in Washington, it's throughout their offices throughout the country. So that just occurred on Friday of last week. Okay. So, oops. So now I want to talk briefly about the appeals procedure. Now, there are different types of appeals procedures. And what I'm going to talk about is I want to talk about the appeals procedure for an individual who is receiving services or who is requesting to be able to receive services. There is a specific vendor appeal also. And if you're interested in that, if you go to dds.ca.gov, which is the DDS website, the Department of Developmental Services website, and you can type in vendor appeal, and it would give you all the information on how, if you're a vendor, how you can appeal first to the regional center and then potentially up to a state level. And that can be anything from if you want a rate adjustment to some other issue related to your vendorization, other things you can. There's an appeal process for vendors, but that's not what we're here today. Today we're going to talk about appeals for individuals, and they can be appeals for either eligibility or for services. Now, anyone who comes to the front door and says, I think I have a developmental disability, occurred prior to the age of 18, and it's substantially handicapping for me in these three areas. There's a list of 7 that you have to find 3 that you're eligible for, can get found to be eligible for the regional center. Now, if someone is not found eligible for the regional center and they believe that they should be, they can appeal that. In addition, if you request a service and the regional center says, oh, we don't buy that, or we don't think that you need that, or that's not consistent with our purchase of service standards, you can appeal that and say, no, I think that this should be part of my plan and I should receive these services and supports. And also, if the regional center comes to the table for your annual meeting and says, okay, you've been getting 40 hours a month of supported living services, and you've been doing great. You're doing, and we believe that we can reduce that now down to 20 hours, that you can, because you're doing so well, you don't need all those hours of supports. And we think that it would increase your independence and ability to do things on your own. And we think it's positive for you. But then you look at the situation and you view it differently. You believe that the reason you're doing so well and the reason you're able to navigate the community and do what your own apartment and do all the things that you're doing is because of that 40 hours of support. And then bringing it down to 20 will significantly decrease your ability to be fully integrated in the settings that you would like. And so you disagree with the regional center's decision. That's also appealable. So if they look at either reducing or discontinuing a service that you're receiving, Okay, so and this is for ages 3 and up. There is a different procedure for the early start for the 0 to 3 year old children because that's under a different federal statute, and so we're not going to really discuss those today. This is from the Department of Developmental Services. They're on their website, a slideshow that they provide that of how the process for appeal works. First of all, the regional center has to send you out what's called a notice of intended action, and everything has an alphabet soup, and it's called NOPA, NOP. So that, and in there they have to say what it is that they're denying, withdrawing, why they didn't find you eligible, etc. And they have to cite the law or regulation that they're using to make their decision. Have to send that out to you. And then you have up to 60 days to get back to the regional center and say you want to appeal. If it's a current service that they're looking at decreasing or eliminating, and if you appeal during the first 30 days, you can go into what's called paid pending, where you can continue to receive that service for until the matter is officially decided one way or the other, and that can take up to 90 days. So it's a good idea if you're going to appeal to try to appeal as quickly as possible. So it just gets the process going. And you send those to the Department of Developmental Services. And then there are 3 different methodologies or 3 different formats that you can do your appeal in. The first one is an informal meeting, and that is usually within 10 days of the appeal request. So if I make a request for an appeal of, I was receiving this day service, and now the regional center feels that it's no longer appropriate for me to attend there, and I continue to want to attend, and we agree to meet informally. The regional center will have somebody, the designee of the director can appoint someone to do that for their behalf, and then you can come or have an authorized representative on your behalf, and you can try to see if you can informally just sit down and discuss it and figure out a way to try to resolve that issue. If you can, then the matter is resolved and and it's over. If you can't, you have 2 other options. One is mediation. Mediation takes place within 30 days of your request, and then that's where an administrative law judge, a judge for the Department of Administrative Services, California Administrative Services, comes down to a setting that you both agree to, and you meet, and the judge listens to both sides and then talks to both sides and says, hey, listen, can you come up with a compromise? This is mediation, not arbitration. Judge doesn't make a decision. Judge just tries to see if he can get the parties to come to some sort of agreement. And that is optional. Both the informal and the mediation are optional. And then finally, you can have a hearing, which has to be held within 50 days, unless there's good cause. And sometimes there is good cause because the Office of Administration hearing can get backed up with a lot of hearings, and so they can't hold all of them in 50 days. But that hearing would be before the administrative law judge, and the administrative law judge would listen to both what you or your representative would have to say, and then also listen to what the regional center has to say. And then they would look at the law or the regulation and see how, based off of the facts that were presented, they can, what decision they should make. It's not like going to court per se. The rules are looser than it would be for going into superior court, but there still are rules, and there are just rules about discovery and what you can do and the format of how it's done. Normally, with that first notice letter that the regional center sends out, there should be a packet that explains the process. And again, contacting advocacy groups like the Office of Clients' Rights Advocacy, Disability Rights California, other organizations can possibly help you as well in terms of your appeal. The process is supposed to be all done within 90 days. The judge is supposed to hear it and then make their decision. It then goes to the director of the Department of Developmental Services, who can, if they feel that there's a need to review it, can review it and then make a final decision, or the judge's final decision holds. And then that becomes the situation. If someone further disagrees with that, they can always go into Superior Court and try to resolve the issue in a more formalized process. So this has been going on for some time. There are some other rules about representation and other things. And again, if you're interested in any of that, just go to the Department of Developmental Services website, and on there is frequently asked questions. There's the packet that the regional center will send out. You can see that, get more information on how the appeals process works. So if you're working with an individual in your day program, in your residence, in your supported living, whatever type of service that you're providing, and they say that the regional center is doing this, or at the IPP meeting, you couldn't come to an agreement, and the regional center is saying, no, we're not going to purchase that, they need to send out the notice. They need to, and then if the individual says, no, I want to disagree with them, potentially helping them with this process could really be advocacy on your part. And like I say, there are other organizations out there too that can help with this. And so I really suggest that you look to that to do that. So that's one type of an appeal. Now, something else that's out there, as well as appeals, there are complaints. A complaint, again, this is Department of Developmental Services information. There's a citizen's complaint, which is just a general issue of concern, not to be used for disputes about eligibility for services or nature or scope or type of services. So if someone just has a concern about the way regional center is doing something, we're not doing something, or would like to see services done differently, or has a feeling that there should be more of a particular type of service, they can file a citizen's complaint. Whistleblower is unique. That is where anyone who feels that there is improper activity going on by either a regional center or by a vendor or by a contractor can file a complaint, and that is done without prejudice. So that if I file a complaint, then that can't come back on me that as repercussions or retribution for making a complaint about something that's occurring to the individuals that we serve. An example of that was a vendor was talking with a individual, and the individual said, hey, I live in a residential home, and my provider took me out the other day, and as kind of a treat, one of the DSPs, not the administrator, not the owner, but one of the DSPs took me out and treated me to a large Hershey bar and a big Coke as a treat. Well, this individual has got pretty involved diabetes and obviously should not have had that. The worker at the day program then complained to did a whistleblower complaint to the service coordinator. The next time that day program worker saw the individual, that individual said, boy, you got me into trouble. Well, how so? Well, that the DSP, the person that works with me, came back and said they got chewed out for doing what they did, and you're responsible for that. So they're not talking to me. They no longer want to work with me because you finked on them. That's retribution. That's the consequences for bringing something forward related to a situation. And but it could be also fiscal. If you're working for somebody and it looks like there's money going the wrong way, or something's not going on, or it's supposed to be a 1-to-6 ratio, and you're oftentimes doing 1-to-10, and so you bring it forth that wait a minute, the provider that I'm working for is not staffing appropriately. That's got to be non prejudicial in terms of that investigation. And then there's what's called an individual rights complaint, which is different. We just talked about appeals a minute ago, where somebody appeals a decision that is made so that they don't get a service is reduced, the service is discontinued, they're found not eligible. Those are appeals. But this is an individual rights situation, is when an individual served, or any representative acting on their behalf of the individual served, believes that the rights have been unfairly denied by the regional center, state operated facility, or a service provider. The complaint must be sent to the regional center or the state operated facility. So in this case, you send it to the regional center. But if you feel that somebody's rights have been denied, either by a care provider, by someone, by the regional center, by some other entity that's involved in our system, some stakeholder, then you can make what they call it, a 4731 complaint. The 4731 is the section of the Lanterman Act, Welfare and Institutions Code, section 4731, where this law is spelled out, and it's taken on the nomenclature of that. Interesting enough, I oftentimes talk about the home and community-based waiver, and how in 2014 the final rule came out, and with those final rules came the 10 rules related to both day and residential services that we're all now following. And over the years, there have continued to be modifications to those. And in 2024, last year, the Center for Medicare and Medicaid Services published an access rule. And this has to do, includes new federal mandates to establish a grievance process for individuals receiving home and community-based waiver services. So the federal government is now stepping in and saying, hey, wait a minute, states, you've got to have this type of grievance process. Now, the Department of Developmental Services, this is one of their slides that I took off their website, says the department currently has multiple complaint procedures with different requirements. So if we go back to this slide here, here's 3 of those complaint procedures: citizen complaints, whistleblowers complaints, individual rights complaints. The department pursues a new combination grievance process that meets access rule federal mandates and include rights violation and citizens complaints. Whistleblower is freestanding. It doesn't change. It continues to be under the mandate for whistleblower. But they're looking at taking the 4731 complaints and the rights complaints and combining those into one new complaints process. Now, currently, you use an individual rights complaint by use for any individual served by the regional center or any representative acting on behalf of the individual served by the regional center believes that their rights have been unfairly denied by the regional center state operator. So if you feel like the rights are denied, you can file an individual rights process complaint. This is the current one, the flow chart of how it works. The individual believes that their rights have been violated or denied. The regional center investigates, and within 20 working days, the regional center response must include a proposed resolution so that how they're going to resolve it. If the individual may appeal to DDS within 15 days if they don't like it, and then the director of the regional center will meet for 45 days. If a violation is found, there must be a plan of correction that the regional center makes or the vendor makes, and then they must complete that plan of correction. So there is a current process, but this will be changing. And this is kind of again a DDS slide showing the current process and the change process. So the new process hopefully will be streamlined. There'll be one form. There won't be multiple forms like there are now. The resolution focuses on individual outcomes. They're going to really work towards what works for that individual. The departments focus on system issues and providing technical assistance. So if it's a regional center, we'll look at for what that for that person. But if the department, in looking at the complaints, sees a trend, we'll be working towards how do we work on that as a system. They're going to an automated system for this. The process available to individuals going through intake and eligibility, as well as ongoing services. The process is available to address issues of home and community-based waiver compliance. So if somebody finds that they feel that a regional center complaining to them that a provider is not following the home and community-based waiver process, this will be a way that a complaint can be made, and the process is available to families and friends and community members with concerns. So stay tuned. This will be put into effect next year in 2026. So currently we're continuing to use the 4731 complaint, the citizens complaint, but those will be combined over the next year or so, and we will be going to a new complaints process. Now, complaints process, there's another complaint process that's out there as well, and that will continue to be sort of freestanding, and that is having to do with Title 17 complaints. And this procedure is to be used when one of the personal rights of an individual who resides in a community care or healthcare facility has been denied. Individual receives services from the regional center disagrees. Now, if you go to the California Code of Regulations, Title 17, and specifically Section 50510, and if you're at all interested in how to get to regulations, so if you see laws or regulations and they're cited in something and you want to get more information, okay, so why are they saying this? And here's the number that's from the state, 515 or 50510. But what does that mean? It means that access rights. Well, what are access rights? Well, if you Google or use one of the other Bing or whatever search engine you're using, and type in California Title 17 50510, or if it's something per se from the Lanterman Act, let's say you wanted to look up the client appeal, that a client was denied a service, and you want to look at the law related to appeals, and that's Section 4700 of the Lanterman Act, you could then type in Lanterman Act 4700, and then it'll take you to that. So you can go ahead and look up a law or regulation on the books. Now, laws, the Lanterman Act is law, and the law says, that the Department of Developmental Services shall make regulations on how to implement this law. So so Title 17 is the California Code of Regulations. So what happens is the Department of Developmental Services writes up regulation to meet the law that's in Lanterman. And then it goes through a process. It goes out for public hearings. So they'll send it out to anyone who's says they're interested, and there's a period where people can make comment. They can send back, okay, we looked at this and we think this is a good rule. We looked at this and we don't agree with this, and we'd like to see this changed, or you didn't think about this, and this is one of the consequences this might have, which isn't necessarily positive. And then the department comes back after the 30-day comment period. They have to review all the comments that they received in writing that they received. And then they have to look to see if they need to make modifications to that document. If they make modifications, they have to put it back out again for review. And then finally, it goes to the office. There's an office that reviews all administrative regulation, and they review it to make sure that it is consistent with the law that it's trying to regulate, and also consistent with the California Constitution. And if it does meet those criteria, it then gets put out as part of Title 17. So if you do look at Title 17, if you go into, like I say, if you Google it and you find a particular section, if you go down to that bottom of that section, it will give you a little bit of history on that section. It'll tell you like when that section was put into regulation, and if there were changes or there were modifications made to that regulation, what dates were those occurred. So you can get a little bit of background of how these regulations came into effect. Now, in this case, when we're talking about Title 17 complaints, we're talking about access complaints. So things like a right to treatment and rehabilitation services. And again, these are right out of this section of Title 17. A right to dignity, privacy, and humane care, a right to participate in appropriate programming of public supported education, regardless of the degree of handicap, a right to religious freedom, to either attend or not to attend, a right to prompt and appropriate medical care, a right to social interaction, a participation in community activities. Now, much of this is very similar to what you have probably on your wall in your program, but those are Title 22 regulations, and most of these mirror each other. So what's in Title 22 is also in Title 17. If you're a licensed facility, you actually have to do both. So I'm showing you Title 17, but there are Title 22, and many of these are duplicate. They're the same thing. That's why I said they mirror each other. But in some cases, they're not exactly the same, and you're responsible for both sets of rules. A right to physical exercise and recreational opportunities, a right to be free from harm, including unnecessary physical restraint or isolation, excess medication, or abuse or neglect, a right to be free from hazardous procedures, a right to advocacy services. So people like protection and advocacy and Disability Rights California, a right to be free from discrimination or exclusion from participation or denial of benefits of any program or activity which receives public funding solely by reason of being a person with a developmental disability. So like I said before, going to that center that was publicly funded and having them saying, no, we don't serve your group, can't do that. They have a right to those services. To protect or assert any right to which a person with a developmental disability is entitled, which is basically the California state constitution, the federal constitution, etc. To question a treatment decision affecting such rights. So if somebody says, okay, we're making this decision on your behalf, you have a right to question that. To inquire into the terms and conditions of placement in any community care facility, to contest a guardianship or a conservatorship. If there is someone files for a conservatorship, the court does appoint someone on behalf of the individual who's being proposed to be conserved. and that person gets representation and can, if they disagree or are able to disagree with that conservatorship, they can. Personal rights. So you have a right to all of the personal rights that are listed. Um, you have a right to be free from harm. A right to be free from, let's see. These look like we've already did this one. I think I've duplicated that slide. To keep and be allowed to spend one's own money and personal and incidental needs, to keep and wear one's own clothes, to keep one's own personal possessions, including toileting articles, to have access to storage space, to have visitors, to have reasonable accommodation. So anyway, to receive mail, to refuse electroconvulsive therapy. That's basically what would used to be called shock treatment. To refuse behavior modification techniques that cause pain or trauma. Age, home and community-based waiver specifically says that you cannot do any adversive treatment. To refuse any psychosurgery. I don't know that anybody has done psychosurgery for many years, but that used to be sort of what they used to call like lobotomies, or they might remove the front part of the brain. Modifications to control thoughts or feelings rather than treatment. And that can be sometimes the use of medication to not so much to treat the disease, but to treat behavior. Modification of normal brain functions, treatment of abnormal brain functions. Okay, other rights specified. Whoops. Okay, so now we're getting to the end of the presentation here. Advocacy and empowerment. Advocacy promotes the rights and social inclusion of individuals with IDD, ensuring their voices are heard. We really want to make sure that people who have a developmental disability are heard and are part of our society. If you go to a regional center board of directors meeting, they have been required for a number of years to have a certain percentage of individuals on their board who are persons receiving services from the regional center. So there is a number of persons who are there. Some of them have a facilitator, somebody helping them to fully understand what's being discussed at the meeting. There's also families of individuals representing all the disabilities that are regional center eligible there. So we try to make sure that we have inclusion and persons who can advocate for all the different disabilities, service and support needs that our community desires, requires, needs, etc. We want to make sure that when we go into meetings, it's person-centered, that it's about the person. It's about their hopes and dreams. It's tailored to their strengths. We're not talking about their deficits. We're talking about what they do well, how we can build on those skills, how we can get them more integrated and included into the community and into services that they're receiving. Supported decision making. Earlier, I mentioned conservatorship. In lieu of conservatorship, more and more we're seeing supported decision making, which is enabling the individual to make informed choices with assistance, promoting autonomy, adherences over guardianship, but it's also conservatorship. Where we sit down with the individuals. Okay, well, here are some choices. This is what the benefit for doing this is. This is one of the problems that you're going to have doing that. This is something over here. Maybe you can try this one, but if you do that, then you know things that you and I just think about all the time when we look at making decisions about our lives. And sometimes we say, okay, if we this will cost us quite a bit more than this other decision would cost us, but then we might be happier with the results, or this is a place that we'd like to go visit, but we can't really afford it, or I'd like to be involved with this church, but if it's way on the other side of town, and I got to decide whether, so all the time we're making decisions and making choices. So the whole idea is if somebody's life needs to have assistance for them to be able to be more independent and to make those choices, instead of having somebody, a third party over them, making those choices for them, let's see about trying to get it so that they can make decisions based off of having the information and getting enough information so that they can decide what they would really like for themselves. Empowering outcomes, empowering strategies, fostering independence, respect, and activity, participating for fulfilling lives of the individual. So we want to do that. Was there a hand raised? If there is, speak up. Okay.
No, Jeff.
Okay. Okay. No problem. Okay, we want to try to get universal design principles, make sure that everything is accessible. Uh, Again, we were talking about inclusive education wherever possible, have children in mainstream settings. Might be more of a challenge now that I just showed earlier that the Department of Education is losing a number of their special education staff. So their ability to be involved, to set policy, to intervene when challenges occur, to fund services are going to be somewhat more of a challenge. We want to try to develop workspaces for people to get people into work so that they can be productive members of society, so that they're producing, that they're tax paying, that they're more typical individuals in our community. And then community-based supports. A few years ago, social recreational services were put back into the budget for regional center services after being taken out in 2008, and they've been out for a number of years, but then they were put back in 2023. And we want to make sure not only do we provide social recreation, but they're social recreational services that are fully integrated with people in the community. So if they're getting involved in a bowling league, maybe having one or two individuals on a team, or if that team is all individuals served by our system, that there may be competing with other teams that are not persons in the system. A call to action. We want to engage public policy. So when you see things as providers, as stakeholders that may have an effect on our system, speak up. Contact our local assemblyman, Vince Fong. Who else? Okay, I'm blocking on her name. But there are other. So Jasmine Baines, our two assembly persons. We have Shannon Grove in the Senate. Those are our local California representatives, and you can contact them and let them know if there's something that you really feel strongly about in terms of services. And oftentimes, if you can bring in an individual who can speak up to meet with them or their staff, that has even greater impact. For many years, I worked when I worked at the regional center. I used to go up to Sacramento every year to lobby one day, and we'd go to the different legislators' offices. We meet with our assemblymen. We would meet with our and women. We'd meet with our state senators, and we would talk with them, and we would share with the issues. We usually had a packet that had all the different issues that we were going to talk about. But what I found was if I had an individual who was receiving services from the regional center with us, who could explain how those services, how going to that day program, how living in that residential facility made the difference that it did for them, that had such a greater impact on the legislature than me, because I was, I'm salaried. I make my living off the system. I have a vested interest. The people that they're serving, that's the legislator seeing where the laws and where the funding and everything that they're doing up there is really making a difference for their constituents. And that's a much more powerful argument. So if you want to promote change or see to the extent that you can assist the folks that we work with to do that really makes a much greater impact. All right, with that, I'm going to, it's as close to 11:30, and I want to make sure I have time for any questions. I always talk very fast and have a lot of material, so hopefully I covered what you would like today, but just in case, any questions? Well, thank you for coming on again. And remember, now we only have one training a month, but stay tuned because not only are you going to be receiving stuff from Bakersfield ARC and Positive Purposes, there will be 6 other stakeholders that will be sending out materials to you regarding home and community-based waiver and how you can continue to provide and enhance the services that you're doing. So good luck to you and hang in there and we'll call it a day. Bye now.
Thank you, Jeff.
Thank you.